Hello everyone, welcome back to the channel where we break down legal cases and laws in Singapore in simple, digestible terms. Today we are diving into a landmark case, the first ever prosecution under Singapore's new law aimed at addressing risks relating to money laundering. Yes, you heard it right. This one's a legal first and it involves a jewelry store, scams and a hefty fine of $35,000. Let's unpack this. So here's what happened. A jewelry store in Singapore, Heng Jewellers and Goldsmiths, found itself in legal hot water after its employees sold gold jewelry to customers who paid using proceeds from scams. These transactions occurred between December 2021 and January 2022. The business was convicted of one charge involving more than $173,000. Under the Precious Stones and Precious Metals Prevention of Money Laundering and Terrorism Financing Act. Now, you might be thinking, did the company know these were illicit funds? According to investigations, the employees were instructed by their supervisor to sell the items without properly verifying the customers' identities or the sources of the money. In total, they accepted over $40,000 in scam proceeds. For this, Heng Jewellers has become the first entity prosecuted under the Corruption, Drug Trafficking and Other Serious Crimes Confiscation of Benefits Act, which imposes the need to conduct a customer due diligence when there is suspicion of money laundering. The company was slapped with a $35,000 fine, a stern reminder that ignorance is no defense in the eyes of the law. Let's talk about the law at play here. Under Section 67(1) of the Corruption, Drug Trafficking and Other Serious Crimes Confiscation of Benefits Act, businesses must perform such customer due diligence measures and internal control measures if there are cash transactions exceeding $20,000, especially those that could be tied to illegal activities like scams. This case is significant because it's the first prosecution under these provisions. It sends a strong message to businesses, large or small, that compliance with anti-money laundering and anti-scam measures is not optional. Let's be clear, this case serves as a wake-up call for businesses in Singapore. With scams becoming increasingly sophisticated, the responsibility to identify and report suspicious transactions has never been greater. While this jewelry store may not have directly participated in the scams, their failure to question suspicious activities indirectly enabled these crimes. Businesses must implement proper training for staff, establish clear compliance protocols, and most importantly, foster a culture of accountability. From a legal perspective, this case sets a precedent. We can expect more prosecutions under the Corruption, Drug Trafficking and Other Serious Crimes Act as Singapore tightens its grip on financial crimes. Ultimately, this landmark case is a step forward in Singapore's fight against scams and financial crime. Businesses, remember, compliance isn't just about following the law. It's about protecting the integrity of our financial system. That's all for today's video. Let me know in the comments below what you think about this case. Should the penalties have been harsher, or was the fine enough to send a message? If you've enjoyed this breakdown, don't forget to like, share and subscribe. Until next time, stay informed and stay vigilant.